ACT is also considered to be the preeminent association for corporate tax professionals who are interested in advancing operational effectiveness through the broad use of technology. As a national nonprofit education organization, ACT is designed to provide a forum for tax professionals to stay abreast of trends in technology and to learn best practices that will help today's tax departments reach new levels of operational excellence. The educational opportunities we offer our members include bi-monthly webcasts such as this one, bi-monthly electronic newsletters, conferences, publications such as survey results, and much, much more. Before we begin today's webinar, there are a few ground rules we'd like to cover. We're trying to keep the lines muted. If you have a question or concern during the session, you can use the chat box feature on the bottom of the screen, which will be monitored by our CFO service representative, and at the end, we will try to answer as many questions as possible. Additionally, we ask that you exit out of all other applications that you're currently running on your computer to optimize today's viewing of the webcast. Today's slides will be made available after the webinar and can be found by clicking through the link on the ACT website. But please allow us a few days for the presentation to be posted. Now I'd like to introduce our presenter for today's webinar, Nick Penko. Nick is the Vice President at CFO Services, and he has worked exclusively with R&D credits over the last 10 years. In that time frame, he has worked with numerous industries and size of companies, including Fortune 500 companies. Nick assists his clients in the areas of service innovation, client relations, strategy consulting, advising, managing other R&D engagement managers, projects consultants at CFO Services, and integrating internal process capabilities for clients seeking every degree of service related to R&D credits. Clients work with Nick because of his experience and his level of attention that he brings to each client. He is currently involved in working directly with the IRS in improving the process for research credit exams. I'm now going to turn the webinar over to Nick.
Excellent. Thanks, Paul. And before you go, how do I sound? Do I sound pretty good? Coming out?
Coming through nice and clear.
Good. Excellent. All right. Well, I'll put the conference line on mute. So,
The leader has muted your line. To unmute your line, press #6.
You should see the chat box below. If you do have a question, we'll try to stop and answer that question if we go through some topics or a slide on there. And the other piece I want to make sure that everybody's aware of, we will record the webinar as well. So if you do ask a question or just, kind of be, sensitive to the fact that we're going to record this, as well as putting the slides on the ACT website later on. All right, I think that is all the housekeeping items, and for us, this is kind of the standard Circular 230 notice that's out there that, any of the information that we share today can't be used for the purpose of avoiding federal tax penalties or any transaction. So just, it's kind of the standard Circular 230 notice that everybody's probably pretty familiar with when giving presentations. But on to the presentation. We have today about an hour slotted. Hopefully we'll get through all the time. And what I want to do is go through the slides, take a couple of them slowly, give anybody who hasn't been familiar with internal use software just a little bit of a background of where it came from, why it is what it is. And the really today is talking about the new software regulations that came out in January. And this is a long time coming, like a 14-year time, hiatus of waiting for these things to really get out there. And so there's a couple key things that came out of these new software regulations, a couple key examples that we want to walk through, and how does this apply to existing, to existing companies, to existing R&D credit claims, and what are the additional things that we can look at, or what are the risks that we can take off if we're talking about a, like a FIN 48 or a UTP type risk towards our software development claims. And then last but not least, I was fortunate enough to attend the hearing on the regulations. So they came out in January, and they had a comment period, and they had the live hearing on Friday in D.C., so I was fortunate enough to attend that hearing, and I can give you some, latest and greatest observations from the hearing as well. So it looks like I think everybody's kind of joined in and chimed in. If you're unfamiliar with the chat, it's just kind of the box at the bottom. Hopefully the slide deck is large enough on your screen. I got it as large as I can, but if something pops up, please, shoot us a chat as we go from there. So that's kind of our agenda. So talking about these software regulations, internal use software, previously within the IRS and within an R&D credit claim was always viewed as kind of not a black sheep, but I'll just say it wasn't viewed in the highest regard, that if you claimed internal use software, it wasn't very qualified. And in fact, internal use software has additional rules that you need to fall under to qualify it. And so if you had internal use software on your research credit, the IRS was most likely going to get into it, and at a lot of times they'll bring in an engineer or even bring in a MITRE expert, which is an outside consultant the IRS uses on software claims. So internal use software had a kind of a long history when we go through exam and getting kind of attached to any type of software development that's out there. And so a long time ago, it seems like a long time ago, but that 2001 time period, we had some regulations, some proposed regulations put out there about some different things from software, but they stayed in that status for a very, very long time. And what has happened is when the research credit was first formed back in the 80s, they put this internal use software exclusion or inclusion in there. But software development back in the 80s is way different than software development is today. So if you think about it, we had a lot of mainframes. We're still the main, that's redundant use of words, but the mainframes were really kind of the main driver of computing technology out there. Where today, we have a lot more, we're now into a cloud, format, and we even had the personal computer kind of format that's actually kind of going to less and less, and now we're going to more of the cloud or the hosted format. So we've had different types of software development, so the internal use wasn't really, back when it was originally defined, Congress really didn't know what today would look like. And so these new software regulations are trying to give a little more credence to the fact that, hey, there's different types of software development. Software is not always going to be something that is, I'm a software company, I'm an XYZ company, and if we all remember that when we first installed Windows or our operating system, we would get like actual floppy disks, where now you download it off the web. That actually difference was being caught up in exams, because the fact that it wasn't a physical delivery of a software, there was problems with that. So these regulations were trying to change some of those items. And some overview of those changes is, the software developed be commercially sold, leased, or licensed, or otherwise marketed to third parties. That's still there. So if I am a company and I develop a software and I go out and I sell this software, be it if it's whatever it might be, whatever software it might be, and if I sell that to a customer, I have customers who are buying my software, downloading my software, who are leasing my software, or however they're using it, that is not classified as internal use software. So that internal use software doesn't have the additional tests, and you can just follow the standard for R&D credit test. And I'll step back for a second. What I'm assuming, as I'm getting into these details, is everybody's familiar with the R&D credit and kind of what typically qualifies and what typically doesn't. This is kind of a subset of that piece of the R&D credit, and I'm assuming everybody who's on here has some familiarity with software development and trying to claim software development for the R&D credit. So if I do kind of make some assumptions in terms of what everybody knows, I apologize. And if you need me to clarify something or kind of give you background, go ahead and ask that question. So internal use software wouldn't be something that is sold. Now, the additional item that they look at is now software developed to enable a taxpayer to interact with third parties or allow third parties to interact with taxpayer systems. This is a whole nother language, rule. And so if I have a software that I don't sell, I don't have to sell it, but taxpayers interact with it, they interact with that system, that is also not an internal use software. And I think everybody probably on the call or on the webinar probably initially thinks about that. Well, that kind of broadens up what is internal use and what is not internal use. And, for the additional one was software developed for hardware products. So if I have a hardware product that I sell and I have a software that goes into that hardware product, that software isn't internal use. That's actually just going to be counted as kind of the part of the hardware. So, some of the issues that we've had in the past, and that we commented a little bit, is that, software that is sold, but it's still located in a taxpayer's location. So one of the things it tries to address is that, we have hosted solutions. And probably everybody who's on the call now in today's, IT world or, delivery of software, there's hosted solutions. So you buy the solution, but the actual location of the software might be in a hosted server or in the cloud. I'll say it that way. And some companies, they'll host it outside of their cloud, or they'll have their own cloud internal in their firewall. But, the companies that are located outside, they're on the taxpayer's location, but their customers are kind of, logging into the server, for lack of a better term. The other piece that, these regulations have in there is software developed primarily for the taxpayer's general administrative functions that support its business. And this is a different set of rules and terminology that I think that in that hearing that I talked about that I went to, there was a couple, issues that might come out of this, and that we see that could be an issue during IRS exam. But in and all of itself, the regulations do try to address the new environment of software and how it's delivered and how it's utilized by customers and taxpayers together. And before I go to that last point, just as a background for everybody, internal use software, so we have the 4 tests for the R&D credit: the technical uncertainty, the process experimentation, technological nature, and a permitted purpose. Those have to be satisfied, and then if it is classified as internal use, it has to satisfy the 3 additional tests of being the software is innovative, it is economic, there's a significant economic risk, and also it's not commercially available to the taxpayer. So those high threshold tests exist, but as you can see, if I'm trying to qualify my software development project, if I don't want to classify it as an internal use software project. I do want to say, hey, it's an external use project. And if I can do that, it's a lesser threshold to qualify. So some of the things that they talk about in the general administrative functions they list is, financial management, human resources management, support services, and marketing. So if you develop a software that is towards those activities, that's going to be a internal use software. But the important distinction is, right, and they actually have this in the preamble to the regulations, is if I am in the business of tax preparation, right? This is in the preamble, is if I'm in the business of tax preparation, I create a software to prepare tax returns. Well, that is technically a general administrative function, but my industry is tax preparation. So really it isn't a general administrative function according to my industry. So there could be some industries that, in another industry, let's say it's manufacturing, it would be general administration. But let's say if it's financial services, it might not be general administrative. So there's a couple things you do have to take a little bit and be careful with, but that gives you a little bit brief overview of the changes. And if anybody's interested after the webinar, you can shoot me an email and I can send you a copy of the proposed rules. And we even have a little memo kind of drafting up some of the key examples that we have gone through here today. Okay, so overall, the IRS's expectations of the regulations is that they have agreed that they're providing a narrower definition of internal use software. So right off the bat, they have acknowledged that, hey, this is going to be a narrow definition. There's going to be more software in development projects that in the past probably would have been categorized in internal use, where now it will be less and less. And they do point an emphasis to smaller entities are probably going to are going to be able to qualify software outside of the internal use definition. And you can think of it this way: all the startups and the little shops that are out there developing, websites, apps, all the different kind of software functionality that that are out there. Those entities probably can start claiming some of these research credits towards that software development. Now, if they can use the credits, that's a different story. But the IRS does acknowledge that the regulations will provide that narrow definition both to larger and smaller taxpayers. So I think we're starting at a good place. I don't ever want to come off as, hey, there's issues with everything that we come out with these regulations. I think there's actually some good things, and there's some expansion of what's going to be included external. And so I think it's good for all types of taxpayers that are out there. But I just want to make sure I couch anything, and I'm not trying to be ultra negative or anything like that. I'm just trying to give a perspective on the regulations. I mean, there's a good number of pages to the regulations, so I can't go through everything today. So I'm just trying to point out the key components. All right, so before I go to the key examples, I'll just kind of pause and take a little, take a little drink of water. But if anybody has any questions, can kind of put them through the chat, and otherwise I'll just move on in a second. All right. I will take the silence as we will keep moving on. And a couple key examples, and this is really where I want to spend the meat of our discussion today, from the regs that I think are very important. And if everybody on the call is familiar with claiming software development for the research credit, or just being part of your software development in your company, you might have some takeaways or some ideas now of additional opportunities you can add to your research credit. So the first example I want to go through is ERP software. So everybody, if you're not familiar with ERP software, enterprise resource planning can mean a lot of different things. Your kind of SAP implementations, that's usually a big item that's going on. Now, historically, those types of implementations have, when you take those through an IRS exam for research credits, have had have been beaten up pretty good. And what the IRS is saying is that all it is just adjusting the settings, or you're just validating, and you're just basically customizing it for for your company's needs. You're not really developing anything. And that's probably rightly so. But the new example, this is a new example that they put in these regs that really doesn't have to deal exactly with the internal use, but it's included in there. It's saying that a company is putting in a new ERP software, and it has to interface with a legacy software. So it might be, let's say it's a payroll human resource system that's out there, just to bring some more clarity to it. And we're having a new ERP software that's there. But the ERP doesn't offer the functionality of the legacy software. So the company wants to go through and develop an interface between the legacy software and the ERP software. And then they go out and they evaluate different, other applications, and they pick one that's, one of the available alternatives out there. Now, so they are, they're unsure about how to keep the data synchronized between the legacy system and the ERP, and there's some issues. So they go through kind of a process of developing a new data caching algorithm to eliminate synchronization problems. That's kind of coming from the actual example. Providing some context to actually go through some testing and some evaluation, and it's a little bit more than just a, hey, we're customizing our settings on our ERP system. We're actually developing an interface between a legacy system and our new ERP system. So with that, the example says those subset of activities, the subset of activities of developing the data caching software and keeping the data of the legacy and ERP synchronized, qualify for the research credit. And that's pretty significant because, it's kind of saying, hey, and it's in the example, it actually is using ERP. It's not saying a new planning software. It's using the term ERP, which everybody's familiar with. So in your ERP implementations, it'll be something that you want to keep an eye on of are we developing any other interfaces, and it's going to be any one-off developments. What still doesn't qualify is, hey, I purchased the package, and my implementation team goes and kind of sets it up, for lack of a better term. And I know people who have gone through ERP implementations are probably laughing because it's not that easy all the time. It's not just a, hey, we buy it, we turn it on, and voila, it's done in a week. We get this implementation. Usually it's a long process for everybody to get this all the way integrated through the organization. But this example is really looking at those developments to interface or link with that ERP development that you can qualify for the research credit now, where previously in exam that was going to be something that is very, very hard, or it was going to be categorized as internal use as well. So that is the ERP example. Any questions that you guys want to provide in the chat before we move on to the next example? Okay. So the next example I want to cover from the regulations, and there's a myriad of examples in there, but I think these are the four best that help provide some definition of how the regulations are expanded. Is we have a function, we have a software. So we talked about general administrative activities. So if we develop a system for tracking inventory, for a very generic kind of term. Now, if we develop the software to do both a general administrative function, but it also allows the third party to initiate functions. So, and I apologize for using the term initiate functions. That's kind of the term that they're using. There's no definition exactly of what that means, which I think will be coming out through the process of IRS exam and other additional revenue rulings and things like that. But we have a dual function software. So we have a software that both does a general administrative function, and it also allows interaction with a third party. So we go through the development, and we can identify, here's how much is towards each section of development. Now, obviously, I'm making some assumptions with that, but because I can identify that subset, so let's say it's 50% third party and 50% general administration, I can say, well, that 50% that's third party isn't an internal use software. And so I don't have to satisfy the 3 additional high threshold tests. I only have to satisfy the original 4 tests for the R&D credit. Now, this doesn't non-qualify the general administrative portion. This just makes it an internal use function, and you have to go through and establish the high threshold test. So this gives a little bit of a, maybe a twist, because sometimes this will be hard, I think, for taxpayers to identify all the time. So if we're developing a system that has interaction with a third party, but how do I go about and identify that development? And there could be different ways. There's not going to be one way or another. And what the regulations are asking for is something that's not really cost related. They want to see, like, if we're making function calls to the software, if we have logs, if we have other software kind of code items that will show the third-party interaction versus the general administrative. So it's not necessarily how much are the costs. It's going to be, how do we show that, this is we have a third party over here and a general administrative over there. But being that said, there's still some opportunity for companies out there to include these items in their research credit, and include that subset and include that piece that's in there. And this will probably fall a lot into the IT departments for your companies. So, your IT departments are out there, implementing or developing software, and some of it could be G&A, and some of it cannot. And so this might be a more reason to get in front of them during the, kind of comparing the R&D credit and seeing if they're doing any of these things. Because I know it's sometimes the IT group might kind of do something and they might think, well, this doesn't qualify because we're just, kind of developing, some basic functions, but maybe it does qualify in what they're doing, and you can kind of include those additional projects. Okay, so the next example which I think the next two are pretty interesting, in doing R&D credits, that I think you can, as I go through these, everybody can probably figure out, a company or something that's out there where these would apply. So this example of the website development, and I was very surprised that these two examples were in there, because I think they're very generous, and almost it could include a myriad of development. So it talks about a manufacturer of various products, and you can think of whoever you want to think of in terms of manufacturer of various products, develops software for a website that allows third parties to order products and track their status of their online order. So I'm a manufacturer, I make a widget, and you can come out to my website and order the widget and then track, track if the widget is on the way to your house, so you can use it later. And also at the beginning of the development, I'm not intending to sell the website for sale, right? I'm not selling the website, but I'm having that interaction with third parties, and that's kind of where that's coming back in. So what they're saying is the software isn't internal use because I allow the third party to initiate functions or review the data. And so if you think about it, website development, if you think about all websites, the intention of a website is not to be internal most of the time. It's going to be an external, I'll back up. External facing websites are intended to be external, to have a third party interact with it or review data. Now, you still have to go through and satisfy the 4 tests of technical uncertainty, process experimentation, and permitted purpose and technological nature. But I think everybody can think about it is previously I would, most website development was categorized as internal use software. And it would be very hard for a company to say, well, it satisfies the high threshold test, because is it innovative, is it significant economic risk, and is it commercially available? Well, I'd have a very hard time trying to get past those tests for my website development. But now we have the lower threshold. I think this opens up a door for, you can think about a lot of companies that are developing websites and developing, order tracking online, systems. Well, we just kind of put the threshold that it's not internal use. So now all that development, if it satisfies those additional 4 tests, can be qualified for the credit. And so, again, this might fall in the IT departments. This might fall within sales and marketing, because sometimes sales and marketing is more responsible for the external-facing websites that are out there. So this website development was one of the very interesting you know, examples that are there. And I don't think I talked about this in one of the first slides. When we talk about third-party interactions, you know, it's either initiating functions or reviewing data. And that is a very generous term, reviewing data, because, you know, you go out to a website and you review the data. It's a very ambiguous term in terms of what it really means. And I think through the hearings, as I'll comment on, is some of that needs a little bit clarification, because you know, how are we going to determine reviewing data in initiating functions, where we've had no definitions of those terms before. So this is kind of new territory for everybody. But again, ordering, you know, an ordering website example is not internal use software. So you can take that as a food for thought, and when you're looking at these items for your research credit, and looking at IT projects or sales and marketing type external web development projects, some of those costs might be able to be included. Now, the next example that I want to talk about is about free website services. So now we have a web destination, right, that offers free services to users. And it could be, you know, a manufacturer offers a free, you know, calculation tool. Like if they're selling a certain industrial product, and you know, here's a free calculation tool for helping you use the product, and it's on the website. Or the example is saying, you know, they develop a software that allows users to upload and modify, you know, pictures at no charge, right? The taxpayer, the company, earns revenue by selling advertisements that are displayed while users enjoy the service. And everybody's probably used some sort of service like that if they've been, you know, on the internet for any length of the time. And they develop the software that has interfaces through which the advertisers can bid for the best position in placing their ads, set prices for the ads, and develop advertisement campaign budgets. At the beginning of the development, the taxpayer or the company does not intend to develop either the software for sale. So you can think of a lot of websites that are out there that have a free service, and they have advertisements kind of all over the page. So the development, the use of the free services and the advertisers are the third parties. So me as the end user of using that uploading the photos, using that service, that's a third-party service, as well as the advertisers moving their ads or paying for more ads to get their ads on certain places. Those are third parties. And so that software is excluded from the internal use because it allows third parties to initiate functions. So very similar to the website development, but different in terms of, you know, there's actually two interactions. We have both the end user and we have both the actual company's customer, if you say it that way, because the advertiser would essentially be the customer of the company. So we have two different places that we have third parties. So, you know, in thinking about this, you don't just think of the end user, you can think of the supplier, for lack of a better term, in that equation too. If I have interaction with an outside advertiser or supplier or vendor or whatever that might be to my website, that can be a third-party interaction, as well as if I deliver it out to a customer or retail or distributors, or, you know, kind of using a bunch of different terms to make the point, that could also be a third-party interaction. So if you think of your companies and your website presence or your internet presence and what the company goes through to develop that presence and what they are you know, allowing third parties to initiate or review data. Some of it could be customer portals. Some of it could be just online. Hey, everybody can have that. It's a public domain. There's a lot of different things that companies do, and I don't want to make any specific examples because I don't want to give anybody the idea that something is internal use versus external use. But I think those 4 examples give you some better guidance of what would be internal use and what would be external use type software. Now again, we want to be in the external use camp, and we still have to pass the additional 4 tests, but those are a lot easier to get through, and the fact that there's an example kind of pushing us into that lower threshold gets us there. So we have these 4 examples: the ERP software, the dual function G&A software, website development, and free website services. So I've gone for a good 20 or so minutes, 25 minutes, maybe even longer if it's probably a little bit longer than that. I'm going to pause for just about 30 seconds, take a sip of water, and then we'll kind of move on to a couple things. But if you do have questions in the chat, go ahead and chime those in, and we'll see if we can get those answered before we move on. Oh, whoops. All right. All right, well, I will keep moving on here. And all right, so the next piece I want to get into is talking about the regulation hearing last Friday. Now, the hearing, all right, so the hearing, if everybody's familiar with the regulations, so they submit the regulations in January and they give I think it's a 90-day comment period to submit comments, and there was about 10 firms, and actually one of them was like a law school that submitted comments on the regulations. And the IRS asked for specifically, one of the big things that they asked for in providing comments was about that third-party interaction. How are we going to determine what is, how do we measure the use of the software interacting by third parties and the not interacting by third parties to initiate functions or review the data. The other area that they asked definition or questions on was middleware and connectivity software. So we talked about interfacing. So if I have a legacy system and I have a new system, I build an interface or a middleware. And what do we define about middleware? Interacting across different networks or bridging software or integration software. They asked specifically about those items. And then third was, when other items that could be used in determining when the internal use software satisfied the high threshold of innovation test. So they asked for specific comments. You could comment on anything else, but you had those 90 days. So we all submitted our comments, I think it was March. Yeah, I believe it was March 23rd, and then they had the hearing scheduled for last Friday, April 17th. And so there were, most of them were, I think everybody in attendance was a, a tax firm or a tax consultant that was there. I didn't recognize or anybody that was with a company per se. So we had a couple companies that provided some live comments, but really it was mostly just summarizing their written comments that were there. If anybody wants to see them, you can actually go out to regulations.gov and you can look up, internal use revenue software, locate the Internal Revenue Service as one of the agencies. And if you look for when comments were submitted, it would be March 23rd. You look for that date, and you should be able to find the internal use software regulations. If you actually want to see, our comments, or, I know a couple different firms like Grant Thornton, KPMG, Price Waterhouse submitted comments as well. So those are all out there, and a couple other ones that did that. So from the IRS's side, who was there? If anybody is, interested, I'll just kind of read off the names. As we had a Danielle Grimm, who's special counsel for pass-throughs and special industries, a Jamie Park, who's also a branch chief for pass-throughs and special industries, and Martha Garcia, who's an attorney for pass-throughs and special industries. And then from the Treasury, we had Christopher Call, who's an attorney advisor for the Office of Tax Policy. And so what, at the hearings, if nobody's been to one, everybody kind of sits in an auditorium. It kind of reminded me of like a college class, that kind of auditorium. And really the panel is there for is really more listening. It's not a debate. It's not a let's go back and forth on what we like, what we don't like. You have about 10 minutes to provide your comments, and they might ask some follow-up questions. But other than that, it's not a discussion. Those are some other things that we've, you can set up with the IRS that's there. So out of the hearing, to give everybody just a little bit of a taste of it, the three things that we really got discussed or commented on was, one, the dual function. So if a software is both internal use and it's third party, the comments were about the difficulty it's going to be of proving one or the other, and the difficulty for a taxpayer to show that. And if they do show that, is that going to be accepted as the method? Because if you think about this example, if I'm dual function, and let's say I use a user log. Every time a user logs in, I can tell if they're external or if they are an internal G&A function. And I use that log. Well, let's say there is a function, code that shows how much data is being reviewed, and that shows a different usage. Well, which report or which version is going to be the method that's going to be relied upon? Because as everybody knows, if there's, the taxpayer could propose one different method, and then the IRS said, well, this is the method we like, and it's really not prescribed one or the other. Now, with all intents and purposes, the taxpayer should have the right to kind of say, here's a reasonable method, and we should go with it as long as it's reasonable. But we all know how exams go, and sometimes it doesn't always come off that way. And so it was kind of, that was one of the discussions, is when we have this dual function. So one of the ideas was, well, if we can prove it's third-party interaction, it's third-party interaction. Because we have a lot of different interactions that can happen, and there's some other nuances that can happen into place, because you could have a third party who is external and a third party that's internal, and how do we kind of distinguish those interactions so it can get a lot of information the taxpayer is going to have to collect just to kind of go through and prove that. So that was one of the comments. The other comment was about the third-party interaction, and as we talked about, initiating functions and reviewing data. What does that mean? It's very general, and I think the panel somewhat commented to say they wanted to leave it general because they didn't want to exclude something that they didn't intend to exclude. And it goes back to kind of the overall thought process is they wanted this to be a narrower definition of internal use, so provide it by making it general. I guess that provides a broader definition. So the third-party interaction being initiate functions or reviewing data has a very broader general term. So keep that in mind as you're kind of doing it. And then last but not least, which I think makes sense in everybody's mind, is the effective date. So the effective date, technically, right now is January. I think it's 15th when they came out, those regulations. It's prospective. It's not retroactive in terms of what. So basically, from that point on, these regulations can be used. But what the commenters were coming out with saying, let's make these retroactive, at least back to a time period. So, because if you think about it, when I calculate my research credit, I have a base period, and for 2015, if and when we get a research credit extended back on the books, I would have one definition of internal use software for 2015, and I would have a different definition for 12, 13, and 14. And that just gets to be a kind of a confusing piece for taxpayers to do that. And so really it's saying, hey, let's make it back to, everybody was proposing different dates, so we don't have all these different ruling. And plus, since we've been waiting for these regulations for so long, you're kind of getting, so really the effective date could be something to piece, because it's really effective from January forward, not anywhere previous. And so that can have some difficulty that's out there. Those are the three items that came out for from the hearing, and all in all, everybody was pretty well positive about the overall regulations, providing some clarity, providing some broadening of what is not internal use. And I think the panel will take those, and they will have to go through, and we'll see if they get final regulations out there or make changes to what's proposed that's out there, or if they take their time on getting this out there. That we don't know. We're all trying to figure it out from who is there and who is not there. So that is my observations from last Friday of being there. It was about a 2.5-hour hearing. If I remember that correctly. So it was pretty well detailed, everybody, but again, there was not really a discussion. It was more of a hearing than anything else. All right, so we have about 10 minutes left. This is, I think, my last slide. And some of the industries and activities that'll be impacted, I think, by these regulations, and maybe this might be one of your companies that's out there. And obviously, I don't have manufacturers or other companies that do development, but I'm thinking more specifically to like an internet hosting company, website development, insurance and banking, financial transactions. So, I do a transaction online now, right? You think about it, even 10 years ago, doing a transaction on my phone. I take a picture of my check, which is, I think, one of the kind of the coolest things. You can and it knows how much it is and does all that processing for you. Those types of items. Online ordering, as we talked about the example. ERP implementation. And I think at the end of the day, I think, and obviously in us providing, services, R&D credit services, is definitely going through IT departments more and talking more about, hey, what website development, what external-facing items are you putting out there from a software perspective that maybe have some items that we can qualify for the research credit. And that's what we're looking at, and hopefully the takeaway today is to ask some of those questions to those people and see if there is anything that's of significance that you want to include on your credit. And obviously, I think everybody, if they've dealt with the credit before, the next step would be going through the 4 tests and obviously getting some documentation behind that. Just because it's not an internal use software doesn't mean it qualifies and we should claim all the credit in the world. It just means we can get to a lower threshold and go from there. All right, so those are that's my presentation. I'll pause for a few seconds and I will open up the chat, see if anybody has any questions. I know I went through a lot of information. And it might be that, hey, you might want to contact me directly or, give me a call or shoot me an email. I think my email is in the other slide, but I'm going to just put it in the chat right now if anybody has it or doesn't have it. And you can email me directly with questions, or if you want to get together at some other time too, I'm fine with doing that, because I know sometimes on these webinars, sharing specific information about what you guys are doing is, you might not want to do that. So feel free. But I'll take a second here, and if anybody has any questions, otherwise I might. And actually, what I'll do is I will open up the line if anybody has any. If they want
The
to ask
leader
a
has
question
unmuted your line.
number 2. All right. Well, I think, Paul, it is back to you, and
Sure.
I will let you kind of close out the meeting here and share some
Excellent.
items.
Great. So thank you very much, Nick. As I mentioned earlier, the slides from today's webcast can be found on the ACT website. That's www.taxact.org, and they should be available in about a week. Also, before we conclude, I'd like to mention our next webinar, which will be on June 16th. It will be hosted by Oracle. Registration for the next webinar will open soon. Additionally, we offer our webinars every other month, so be sure to check out our website and watch your email for more information. The ACT conference is coming up very soon. It will be next month, May 18th through the 20th at the Sanibel Harbor Marriott Resort in Fort Myers, Florida. Don't forget the $75 registration discount will expire this Friday, so register as soon as you can. The conference will feature presentations by tax, technology, and tax technology professionals. And this will be the only opportunity via ACT this year to network with your peers and with the tax and technology industry leaders. So you won't want to miss this event. Also, make sure to check out our website to find relevant information and materials that will help you achieve operational excellence within your organization, such as our bi-monthly news, previous webinars, and much, much more. We'd like to thank everyone for attending, as well as Nick and CFO Services for hosting and sponsoring this webcast. If you'd like to join ACT or like more information regarding ACT, please visit our website at www.taxact.org. Thank you all again for attending, and this webcast has now ended.